You've just received a letter from the legal aid agency. It's a no. This isn't just you. To get full legal aid, a single person needs a disposable monthly income below 733s. Years of cuts have created a massive rise in people forced to represent themselves in court. This doesn't just hurt individuals, it slows down the entire justice system, a problem magistrates have called serious. But a denial isn't the end. We'll show you 5 concrete steps you can take right now to challenge this and find help. So, where do you begin? Your first step is to become a detective. The most important piece of evidence is the refusal letter itself. This letter isn't just a rejection, it's a roadmap for your appeal. Your entire strategy hinges on understanding their specific reasons for denial. Look for key phrases. Is it financial ineligibility? Or the merits of your case? It could even be a simple procedural error on your application. Once you know the why, you face a choice. Path 1. A formal appeal against their legal reasoning. Path 2. A financial reassessment. This is not an appeal. It's for when your money situation has changed significantly. Choosing the right path first is vital. Appealing a financial decision is a waste of time if a simple reassessment will work. But what if your finances are the same and you believe the legal aid agency just got it wrong? How does the formal appeal actually work? Your first stop is an internal review. You're asking the legal aid agency to look at its own decision again. You must act fast. There is a strict deadline, often just 14 days from your refusal. Miss this, and your chance to appeal could be gone forever. If the internal review fails, you can escalate it. Your case goes to an independent funding adjudicator, or IFA. This is your first chance to have someone outside the legal aid agency review your file. For very high-cost cases, it goes even higher. The formal appeal is rigid. But what if your life has changed since you first applied? This is where the financial reassessment comes in. Denied for financial reasons? If you've lost your job, had a serious illness, or divorced, don't appeal. Request a reassessment with new evidence. But what if your case isn't normally covered at all? There is a supposed safety net called Exceptional Case Funding, or ECF. ECF is for cases where denying you aid would breach your human rights, like a serious risk to life. It's meant to be the last line of defense for justice. But there's a huge problem with this safety net. When the scheme began, success rates were shockingly low, with high initial refusal rates. The application is notoriously complex. Senior judges have even called it a fig leaf, hiding the impact of legal aid cuts. It's so difficult that many legal aid lawyers avoid it. They fear they won't get paid for hours spent on a likely failed application. To make it worse, the agency itself has been criticized for not clearly explaining why they refuse, robbing people of a fair chance to appeal. So the official paths are full of pitfalls. It can feel hopeless. But this is where we shift focus. Where else can you turn for real, practical help? Recall the rise of people forced to go it alone. This created a crisis that volunteer lawyers are trying to fill. This is the world of pro bono. Key names to search are Law Works for Solicitors, Advocate for Barristers, and the Free Representation Unit for Tribunal Help. Here is why this is so important. The LAA may deny you on merits, saying your case is too weak, but this can be a flawed judgment. Some charities took on asylum appeals, denied legal aid, and won, proving that representation itself creates merit. It's the difference maker. The answer is often yes. Check your home or car insurance policies. Many include legal expenses insurance that can cover your costs. If you are facing eviction, there is a crucial service, the Housing Possession Court Duty Scheme. It provides free representation on your hearing day. Also, Look for fixed-fee consultations with solicitors and try the government's civil legal advice phone line. These are cost-effective first steps. Let's recap the 5 steps. 1. Decode your letter. 2. Choose appeal or reassessment. 3. Consider ECF cautiously. 4. Hunt for pro bono. 5. Uncover other funding. A legal aid denial feels like a closed door, but it is not the end of the road. It is the start of a new strategy. In a system where justice can feel inaccessible, knowing these steps is your most powerful tool. It's how you reclaim your path to a fair hearing.